The airline's own chatbot told Jake Moffatt exactly what to do. It said, "Buy the ticket now. Travel to your grandmother's funeral. Then apply for a bereavement discount within 90 days. You'll get a partial refund." That's how it works. Moffatt bought the ticket, flew to the funeral, applied for the refund. Air Canada said, "No. That policy doesn't exist. The chatbot was wrong. Not our problem." What happened next set a legal precedent that no airline, no tech company, and no chatbot deployment in the world was prepared for. November 2022. Jake Moffatt gets the call. Their grandmother has died. She lived across the country, a flight away. The funeral would happen in days. Last-minute bereavement flights are expensive. This is not a secret. Airlines know the math. When someone has to be somewhere urgently and emotionally, they will pay whatever it costs. Moffatt needed to get there. The question was how to do it without paying full price. Air Canada had a bereavement fare policy, a discount for people traveling to funerals or to visit relatives on their deathbeds. But the policy had conditions, timing rules, documentation requirements. The specifics mattered. Moffatt didn't dig through the policy page. Instead, they opened the chatbot on Air Canada's website and asked directly. The chatbot was a customer service tool deployed by Air Canada. It was meant to answer questions, reduce the load on human agents, and give passengers fast, accurate information. It had been placed on the site by Air Canada. It spoke in Air Canada's name. It told Moffatt, "Buy the ticket now, travel, then apply for the reduced fare retroactively within 90 days. The chatbot even provided a link to Air Canada's own bereavement travel page. Moffatt took screenshots, bought 2 tickets, flew to the funeral, returned home. The total cost of the tickets was $1,640 Canadian dollars. When Moffatt submitted the refund request, Air Canada's response was blunt: "The bereavement policy doesn't work that way. Reduced fares must be requested before the flight, not after." The chatbot had given incorrect information. The refund was denied. Moffatt sent Air Canada the screenshots. "Here is what your chatbot told me. Word for word." Air Canada's response acknowledged that the chatbot had used misleading words. It was not a denial. It was an admission. And then Air Canada said it still wasn't paying. The airline's position, at this point, was something close to, "Yes, our tool told you the wrong thing, but you should have verified it against our website anyway." The chatbot and the policy page contradicted each other. Moffatt had trusted the chatbot. That was, according to Air Canada, Moffatt's mistake. There is something worth pausing on here. Air Canada had deployed a customer service chatbot specifically so that customers wouldn't have to dig through policy pages. That was the tool's purpose, to be the convenient, accessible, accurate version of information that might otherwise require navigating menus, reading fine print, or waiting on hold. Moffatt had used the tool exactly as intended. And now the company was arguing that using its own tool had been a customer error. The amount in dispute was $650 Canadian dollars and 88 cents, the difference between what Moffatt paid and what they would have paid under the bereavement fare. Not a large sum. Not the kind of number that typically ends up before a judge. But Moffatt filed a claim with the Civil Resolution Tribunal of British Columbia anyway. The Civil Resolution Tribunal is a small claims court for British Columbia, designed to handle disputes that don't justify the cost of full legal proceedings. Cases are handled primarily through a structured online process. Most claims are for amounts under $5,000. The tribunal handles disputes that would otherwise be economically irrational to litigate, exactly the kind of situation where companies routinely calculate that a small wrongful charge is cheaper to keep than to defend. Air Canada had made that calculation. The refund was less than $1,000. Fighting the tribunal claim might actually cost more than paying. But the company chose to fight anyway. And it arrived at the tribunal with an argument that stopped the proceedings cold. The chatbot, the airline said, is a separate legal entity. It is responsible for its own actions. Air Canada cannot be held liable for information the chatbot provides. If the chatbot gave incorrect information, that is between the customer and the chatbot. The tribunal adjudicator, Christopher Rivers, read this argument. Then he wrote his response. In effect, Rivers wrote, Air Canada suggests the chatbot is a separate legal entity that is responsible for its own actions. This is a remarkable submission. He rejected it entirely. Air Canada, Rivers ruled, is responsible for all information on its website, including information provided by automated tools it deploys. The chatbot is not a separate legal entity. It is part of Air Canada's operation. Air Canada built it, placed it on its site, and directed customers to use it. The ruling came down on February 14, 2024. Valentine's Day. Rivers found that Moffatt had been misled by Air Canada's chatbot through negligent misrepresentation. He ordered Air Canada to pay 812 Canadian dollars and 2 cents, 650 Canadian dollars and 88 cents in damages plus additional costs. Air Canada paid. The dollar amount was small. The implications were not. The Air Canada ruling was the first time a court, anywhere, had held a company legally liable for false information provided by its own AI chatbot. It established, in writing, that deploying an AI tool to interact with customers is not a way to create distance between a company and its responsibilities. The chatbot speaks for the company. What it says is what the company said. Legal analysts in Canada and the United States noted the case immediately. The ruling was narrow: one tribunal, one province, one relatively modest claim, but the principle it articulated was broad. If you put an AI tool in front of customers, you own what it tells them. This matters enormously because of what was happening in the corporate world at the time of the ruling. By early 2024, chatbots had become standard infrastructure for companies of every size. Banks were using them to answer questions about interest rates and overdraft policies. Insurance companies were using them to explain coverage terms. Hospitals were using them to help patients understand billing. Retailers were using them to process returns and answer product questions. Airlines, including Air Canada, were using them as the first point of contact for nearly every customer inquiry. Most of these companies had not considered the liability question. They had considered the cost savings. They had considered the deployment timelines. They had considered the customer satisfaction scores that could be achieved by answering questions in under a minute. They had not, in most cases, built rigorous legal frameworks around what happened when the chatbot was wrong. The Air Canada case was a warning delivered in a Canadian small claims tribunal. The next version of that warning might come from a federal court, with vastly higher stakes. The Air Canada case was watched closely in legal circles for another reason. It was the first case to directly address the question of chatbot liability in a consumer context, and it was decided not by a technology court or a specialized tribunal, but by a body designed to handle everyday disputes between ordinary people and the companies they deal with. That ordinariness matters. The Civil Resolution Tribunal of British Columbia exists because the legal system recognized that most disputes, the ones that affect real people's daily lives, don't justify the cost of full legal proceedings. Moffatt couldn't hire a lawyer to fight for a $650 refund. The system was designed so they didn't have to. They filed the claim themselves, through an online portal, and a trained adjudicator reviewed the facts. And in that ordinary setting, a $1 trillion airline's argument, that it wasn't responsible for what its chatbot said, was demolished in a few paragraphs. There is something clarifying about that. The most sophisticated legal argument Air Canada could offer, in defense of a few $100s, was that software is a separate legal entity. And an adjudicator sitting at a small claims tribunal said, in plain language, no it isn't. You put it there. You're responsible for what it says. That sentence, in various forms, will be cited in courts for years. The tool was redesigned to direct users to live agents for complex policy questions rather than attempting to answer them directly. The bereavement fair section was restructured. Where the chatbot had previously given specific procedural guidance, it now hedged, directing customers to call, to check the website, to speak with a representative. This was the quiet corporate response to a court loss: make the tool less useful in the specific area where it had been proven wrong. Not more accurate. Less specific. That is a telling choice. The goal was not to build a chatbot that gave correct answers about bereavement fairs. The goal was to build a chatbot that couldn't be held responsible for wrong answers. The information was still there, on the website. The policy still existed. But the tool that was supposed to surface it accurately had been rebuilt to stop trying. Moffatt, for their part, received the 812 Canadian dollars and 2 cents. The refund arrived 14 months after their grandmother died. The amount covered roughly half of one of the 2 tickets they had bought. The legal fee for the tribunal claim was included in the damages. So was a small additional penalty for Air Canada's failure to respond reasonably before the case was filed. In a narrow legal sense, Moffatt won everything they had asked for. The technology companies building chatbots right now, the ones being dropped onto airline websites, bank portals, hospital intake forms, insurance claim systems, are watching this case. Some of them are quietly updating their terms of service. Others are adding disclaimers. A few are restructuring how their tools respond to policy questions. What none of them can do is pretend the ruling didn't happen. The ruling established something that seems obvious in retrospect but apparently needed a judge to say it. A company cannot put a tool in front of its customers, instruct those customers to use that tool, and then disclaim responsibility when the tool gives wrong information. The fiction that a chatbot is a separate entity, immune from the obligations of the company that built and deployed it, did not survive contact with a British Columbian adjudicator. What the ruling didn't settle is how this principle scales. Air Canada's chatbot gave wrong information about a bereavement fare refund. What happens when a bank's chatbot gives wrong information about mortgage rates? When a health insurer's chatbot gives wrong information about coverage limits? When a hospital's chatbot gives wrong information about medication interactions? The $812 Canadian dollars and 2 cents was a rounding error in Air Canada's legal budget. The next case might not be. The ruling also had an immediate practical effect on how companies were thinking about AI deployment in consumer-facing contexts. Legal teams at airlines, banks, insurance companies, and retailers began reviewing their chatbot terms of service. The question they were trying to answer was, does our deployment structure create the same liability that Air Canada's did? For most of them, it did. A chatbot placed on a company's website, answering questions in the company's name, was indistinguishable, from a legal standpoint, from a chatbot that explicitly said I represent Air Canada. The channel made no difference. The company was on the hook. Air Canada spent more on lawyers than the claim was worth. They argued that a piece of software they built, trained, deployed, and placed in front of millions of customers was, legally speaking, not their responsibility. A judge disagreed. Somewhere right now, a chatbot is answering a question. It is confident. It is fast. It is wrong. And when the answer costs someone real money, or a funeral trip, or a medical decision, or a home, whose name goes on the liability, the bot doesn't have one. The company does. The question is whether anyone makes them use it. If you think more people need to hear this story, share it. And subscribe, because this isn't the last time AI changes someone's life.